Welcome back to SCOTUS Oral Arguments and Opinions. This is the second of 4 episodes for today. In this episode, we'll discuss the June 26, 2025 Supreme Court opinion in the case called Medina versus Planned Parenthood South Atlantic, case number 23-1275. Please note that this summary is read by an automated voice. In this case, the Supreme Court ruled 6-3 that Medicaid beneficiaries cannot sue states under Section 1983 for violating the federal law requiring patient choice of healthcare providers. The court held that Congress did not use sufficiently clear, rights-creating language in the Medicaid statute to allow private enforcement lawsuits against state officials. Justice Gorsuch's majority opinion established that spending power statutes must closely resemble previously approved statutory language to create enforceable individual rights. The decision makes it significantly harder for individuals to enforce federal program requirements through civil rights lawsuits, potentially affecting enforcement across numerous federally funded programs. In this episode, we'll walk through each justice's reasoning, from the majority's restrictive approach to Justice Thomas's call for wholesale Section 1983 reform to Justice Jackson's defense of civil rights enforcement. Then we'll analyze where these very different judicial philosophies aligned and clashed, and explore what this decision means for the future of federal civil rights law. The questions presented in this case are: 1. Whether the Medicaid Act's any qualified provider provision unambiguously confers a private right upon a Medicaid beneficiary to choose a specific provider. 2. What is the scope of a Medicaid beneficiary's alleged right to choose a provider that a state has deemed disqualified? Justice Gorsuch delivered the opinion of the court in which Chief Justice Roberts and Justices Thomas, Alito, Kavanaugh, and Barrett joined. Justice Thomas filed a concurring opinion. Justice Jackson filed a dissenting opinion in which Justices Sotomayor and Kagan joined.
Justice Gorsuch's majority opinion. Congress created Medicaid in 1965 to subsidize state health care for families and individuals whose income and resources are insufficient to meet the costs of necessary medical services. Section 1396-1. Medicaid offers states a bargain: federal funds in exchange for compliance with congressionally imposed conditions. To participate in Medicaid, states must submit a plan for medical assistance, satisfying over 80 conditions in Section 1396AA. If a state fails to comply substantially with any condition, the Secretary of Health and Human Services may withhold federal funding. Section 1396C. This case involves the any qualified provider provision in Section 1396 AA 23A, which requires states to ensure that any individual eligible for medical assistance may obtain it from any provider qualified to perform the service, who undertakes to provide it. The provision does not define qualified, leaving that to states' traditional authority over health and safety matters. The question is whether individual Medicaid beneficiaries may sue state officials under 42 U.S.C. Section 1983 for failing to comply with the any qualified provider provision. Planned Parenthood South Atlantic operates 2 clinics in South Carolina, offering a wide range of services to Medicaid and non-Medicaid patients. It also performs abortions. Citing state law prohibiting public funds for abortion, South Carolina in July 2018 determined that Planned Parenthood could no longer participate in the state's Medicaid program. At the same time, the state took steps that, it said, would help ensure that other providers would continue offering necessary medical care and family planning services. Planned Parenthood and patient Julie Edwards sued, claiming the exclusion of Planned Parenthood violated the any qualified provider provision. Edwards alleged she preferred Planned Parenthood for gynecological care, but needed Medicaid coverage. They brought a Section 1983 class action to vindicate rights secured by the federal Medicaid statutes. Section 1983 allows private parties to sue state actors who violate their rights under the federal Constitution and laws. But federal statutes do not automatically confer Section 1983 enforceable rights. This is especially true of spending power statutes like Medicaid, where the typical remedy for violations is federal funding termination, not private suits. The district court granted summary judgment for plaintiffs and enjoined the exclusion. The Fourth Circuit affirmed. This court then granted certiorari, vacated, and remanded in light of Health and Hospital Corporation of Marion County v. Talevski, which addressed whether another spending power statute created Section 1983 enforceable rights. On remand, the Fourth Circuit reaffirmed. Held, Section 1396 23A does not clearly and unambiguously confer individual rights enforceable under Section 1983. A. Congress sometimes allows private enforcement through Section 1983, which authorizes suits against state actors who deprive individuals of federal rights, privileges, or immunities. But statutes create individual rights only in atypical cases. Section 1983 provides causes of action for deprivation of rights, not mere benefits or interests. To prove an enforceable right, plaintiffs must show the statute clearly and unambiguously uses rights-creating terms with an unmistakable focus on individuals. This is a stringent and demanding test. Even qualifying statutes may be unenforceable if Congress provided alternative remedies. These rules vindicate separation of powers. Courts once assumed authority to provide whatever remedies seemed necessary for statutory purposes. But statutes do not pursue single purposes at all costs, and Congress may not wish to authorize private suits. Deciding whether to permit private enforcement poses delicate policy questions involving competing costs and benefits, decisions for elected representatives, not judges. B. Spending power statutes are especially unlikely to confer enforceable rights. Unlike Commerce Clause or other regulatory powers, Congress's spending authority rests on the taxing clause, which does not expressly authorize regulating conduct or issuing direct orders to states. Early courts described federal grants as contracts, not commands. Federal-state agreements resemble treaties between two sovereignties. Treaties may benefit citizens, but generally do not confer individually enforceable rights against sovereigns, instead depending on the contracting governments for enforcement. Thus, Congress alone has the power to enforce grant conditions. C. In Penner's State School and Hospital v. Halderman, the court established that spending power legislation is much in the nature of a contract. The typical remedy for state noncompliance is federal funding termination. Private enforcement requires showing states, voluntarily and knowingly, consented to private suits, meaning Congress must clearly and unambiguously alert states that private enforcement was a funding condition. Gonzaga held that spending power legislation cannot support Section 1983 suits unless Congress speaks with a clear voice and manifests an unambiguous intent to confer individual rights. Only unmistakable notice suffices. Talevski reaffirmed that Gonzaga sets forth the established method. Statutory provisions must unambiguously confer individual federal rights, a demanding bar cleared only in atypical cases. The statutes there qualified because they expressly used clear rights-creating language. Earlier cases like Wilder v. Virginia Hospital Association, Wright v. Roanoke Redevelopment and Housing Authority, and Blessing v. Freestone suggested less demanding standards, but Gonzaga rejected any approach permitting anything short of an unambiguously conferred right. Lower courts should not rely on these repudiated precedents. D. Section 1396 AAA 23A lacks the required clear rights-creating language. Since Pennhurst, only 3 sets of spending power statutes have been found to confer Section 1983 rights, those in Wright, Wilder, and Talevski. Given this court's repudiation of Wright and Wilder's reasoning, Talevski provides the only reliable measure. Talevski addressed Federal Nursing Home Reform Act provisions requiring facilities to protect and promote residents' right to be free from restraints, and provisions titled Transfer and Discharge Rights in a subsection called Requirements Relating to Residents' Rights. The Any Qualified Provider provision looks nothing like these. Section 1396 AEAA A23A states that Medicaid plans must provide that any individual eligible for medical assistance may obtain such assistance from any qualified provider. This language addresses state duties and may benefit providers and patients, but lacks FNHRA's clear rights-creating language. Congress knows how to create clear rights, as FNHRA shows by giving nursing home residents the right to choose a personal attending physician. But that is not the law here. The provision's exceptions confirm this reading. States may exclude providers convicted of a felony and determine which convictions qualify. This makes sense if the provision addresses state duties to the federal government, but creates problems if it also confers individual rights. Congress would grant rights in one breath, while letting states control their scope in the next. The statutory context supports this conclusion. The Medicaid Act requires only substantial compliance, Section 1396C, suggesting focus on aggregate compliance with federal obligations rather than rights of any particular person. The provision appears as paragraph 23 of 87 plan requirements directed to the Secretary without discernible organizational principle. If Section 1396 AA23A created individual rights, many similar Medicaid provisions would too, making rights-creating provisions the rule rather than atypical exceptions. E. 4 counter-arguments are offered. First, the claim that Congress modeled Section 1396AA A23A on a Medicare provision titled Free Choice by Patient Guaranteed, but no court has addressed whether that Medicare provision creates Section 1983 rights. Moreover, while the Medicare provision guarantees patient free choice, the Medicaid provision never uses guarantee or free choice. Congress omitted the very language claimed to create rights. Second, the appeal to legislative history suggesting Congress intended individual rights. But statutory interpretation focuses on what Congress enacted, not speculated intentions. For spending power statutes, the key is not what a majority of the members intend, but what the states are clearly told. Third, the proposal to remodel the established test by arguing that individual-centric, mandatory language is necessarily rights-creating without requiring the explicit rights-creating terms this court has long required. This standard lacks foundation in precedent and obliterates the distinction between mere benefits and enforceable rights. It would make rights-creating provisions the rule rather than atypical exceptions, and leave states guessing about their obligations. Fourth, the policy argument that only Section 1983 litigation can effectively enforce the provision, claiming the federal government lacks capacity or appetite for funding cutoffs. This court has rejected the notion that funding cutoffs are too massive to be realistic relief. Alternative enforcement exists. States have administrative processes for provider challenges, reviewable by state courts. If existing remedies prove insufficient, Congress can create new ones. But balancing enforcement costs and benefits is a policy question for Congress, not courts. Reversed and remanded.
Justice Thomas's concurring opinion. I join the court's opinion in full. I write separately because it behooves us to re-examine more broadly this court's Section 1983 jurisprudence, which bears little resemblance to the statute as originally understood. In appropriate cases, we should reassess Section 1983's bounds, including its application in the spending context and our understanding of the rights enforceable under Section 1983. The history of Section 1983 makes clear that the statute has exceeded its original limits. Section 1983 originated as a narrow Reconstruction-era statute. Congress enacted Section 1983 as Section 1 of the Civil Rights Act of 1871, designed to enforce the provisions of the 14th Amendment in response to an ongoing pattern of violence and intimidation against former slaves. In its original form, Section 1983 provided a means by which private plaintiffs could obtain redress from state and local officials for certain constitutional violations. Although the text of Section 1983 has remained largely constant, the judicial understanding of its scope is an entirely different matter. At the time of its enactment, Section 1983 was the least controversial provision in the 1871 Act, attracting little attention or debate. The provision spawned relatively few cases for many decades. When courts did face Section 1983 cases, they construed the statute narrowly. This court's Section 1983 jurisprudence took a sharp turn when the court decided Monroe versus Papey. Monroe thus breathed new life into Section 1983. The court continued to broaden Section 1983 in the years that followed. The upshot of these decisions was that Section 1983 can reach any and all violations of rights secured by the Constitution or federal law. The consequence is that litigants can now invoke Section 1983 to challenge myriad state actions that have little or nothing to do with civil rights. This jurisprudential shift has transformed Section 1983 litigation. The scant resemblance between Section 1983 today and Section 1983, as it was traditionally understood, creates good reason to doubt our modern understanding. To ensure that we are not elevating demonstrably erroneous decisions over duly enacted federal law, we should, in appropriate cases, revisit the proper bounds of Section 1983. This case implicates two problems, in particular, the extension of Section 1983 into the spending power context and an ahistorically modern understanding of the rights protected by Section 1983. As I explained at length in Talevski, this court has erred in extending Section 1983 into the spending power context. Section 1983 provides a means to redress the deprivation of rights, privileges, or immunities secured by the Constitution and laws. But legislation enacted under Congress's spending power cannot secure rights as required by Section 1983. Conditional spending legislation does not itself secure any rights. Accordingly, any third parties who benefit from those obligations cannot derive an enforceable federal right from the legislation. I therefore continue to think that the Talevski majority erred. In a case where the issue is properly presented, I would make clear that spending conditions, which are by definition conditional, cannot secure rights. Separately, I question whether our current understanding of Section 1983 is overbroad with respect to the range of rights, privileges, or immunities covered by that statute. Our cases have glossed over the threshold question of what constitutes a right under Section 1983. We should revisit the threshold question of what constitutes a right under Section 1983. Because we interpret statutes at the time of their enactment, the answer to that question turns on how ordinary readers would have understood the phrase rights, privileges, or immunities in 1871. And it seems more than likely that contemporaneous readers would have understood those terms more narrowly than our current Section 1983 doctrine does. Only in the 1960s and 1970s did the court replace its traditional distinction between rights and benefits with a dramatically expanded conception of rights. The modern Section 1983 framework developed during the same period as this rights revolution, and the court's shift inevitably influenced the court's understanding of rights in the Section 1983 context. In light of the distinctly modern nature of our Section 1983 jurisprudence, I doubt that we have correctly interpreted the term rights for purposes of Section 1983. The court properly applies our precedents to resolve the question presented. But given the remarkable gap between the original understanding of Section 1983 and its current role, a more fundamental re-examination of our Section 1983 jurisprudence is in order.
Justice Jackson's dissenting opinion. The Civil Rights Act of 1871 was an exercise in grand ambition. It had to be. In the wake of the Civil War, the American South was consumed by a wave of terrorist violence designed to disenfranchise and intimidate the country's newly freed citizens and their allies. The threat was existential, not just for the newly liberated, but for democracy itself, and required bold intervention. A century and a half later, the project of stymieing one of the country's great civil rights laws continues. In this latest chapter, South Carolina urges our court to adopt a narrow and ahistorical reading of the 1871 Act's first section, which is codified today at 42 U.S.C. Section 1983. That venerable provision permits any citizen to obtain redress in federal court for the deprivation of any rights, privileges, or immunities secured by the Constitution and laws of the United States. South Carolina asks us to hollow out that provision so that the state can evade liability for violating the rights of its Medicaid recipients to choose their own doctors. The court abides South Carolina's request. I would not. For that reason, I respectfully dissent. The dispute in this case arises from South Carolina's failure to comply with the free choice of provider provision. In 2018, the state's governor issued an executive order deeming all abortion clinics unqualified to provide health care services and directing the state's Department of Health and Human Services to terminate them from the state's Medicaid program. Edwards filed this lawsuit against state health officials under Section 1983, seeking to enjoin PPSAT's termination from the Medicaid program. She asserted that the termination decision violated her rights under the free choice of provider provision to obtain care from her doctors of choice. The majority accepts that the touchstone for that inquiry is whether the law in question unambiguously confers individual federal rights. But the opinion it hands down today suggests that, as a practical matter, the character of the law, and in particular whether it was enacted under Congress's spending power, is all but dispositive of the required rights determination. That view distorts the unambiguous conferral test beyond recognition and strains our precedential holding that Section 1983's unqualified use of the word laws means exactly what it says. Under a faithful application of our unambiguous conferral test, the Medicaid Act's free choice of provider provision readily creates an enforceable right. The Civil Rights Act of 1871 was designed to bolster the protections of the Civil War amendments and earlier Reconstruction statutes, which had failed to prevent postbellum state actors from continuing to deprive American citizens of federally protected rights. The text of that provision, now codified at 42 U.S.C. Section 1983, is straightforward. It authorizes private individuals to sue state or local officials who deprive them of any rights, privileges, or immunities secured by the Constitution and laws of the United States. Mindful of the statute's ambitious goals, the court has traditionally given full effect to its broad language, recognizing that Section 1983 provides a remedy to be broadly construed against all forms of official violation of federally protected rights. Medicaid's free choice of provider provision easily satisfies the unambiguous conferral test. To start, the text of the provision is plainly phrased in terms of the persons benefited, namely Medicaid recipients. This individual-centric formulation reflects an unmistakable focus on the benefited class. Congress also used rights-creating language in the heading of the provision when it enacted the original session law. The provision was entitled Free Choice by Individuals Eligible for Medical Assistance. This phrasing indisputably invokes language classically associated with establishing rights, and Congress reinforced its rights-creating intent by making the provision mandatory. It specifically inserted the word must into the statute to make clear that the obligation imposed on the states was binding. The provision's history confirms what the text makes evident, that Congress intended the provision to be binding. Congress enacted the free choice of provider provision in 1967, just 2 years after the original Medicaid Act. in direct response to efforts by some jurisdictions to steer Medicaid beneficiaries to specific providers. To prevent states from interfering with Medicaid recipients' freedom to choose their own providers, Congress adopted nearly identical language from a provision of the Medicare Act that, in both purpose and effect, had guaranteed that right to Medicare beneficiaries. Congress's intent could not have been clearer. The majority's effort to resist the natural and obvious rights-creating reading of the Medicaid Act's free choice of provider provision is ultimately unpersuasive. The court holds that the provision does not confer any individual rights on Medicaid recipients, but reaches that conclusion by applying a version of the unambiguous conferral test that we did not endorse in Talevski or Gonzaga. In doing so, the court adopts an approach to Section 1983 that not only undermines the statute's core function, but also stretches our doctrine beyond anything that can be justified as a matter of text, precedent, or first principles. The approach that the court follows today differs conspicuously from the approach we developed in Gonzaga and reaffirmed in Talevski. Instead, the court builds its analysis around the simplistic premise that Medicaid's free choice of provider provision looks nothing like the FNHRA provisions we upheld in Talevski. That approach warps our reasoning in Talevski. Nowhere in our opinion did we single out FNHRA as the sole or definitive model for conferring individual rights. Congress enacted the Medicaid Act's free choice of provider provision to ensure that Medicaid recipients have the right to choose their own doctors. The court's decision to foreclose Medicaid recipients from using Section 1983 to enforce that provision thwarts Congress's will twice over. Once, in dulling the tool Congress created for enforcing all federal rights, and again in vitiating one of those rights altogether. The court's decision today is not the first to so weaken the landmark civil rights protections that Congress enacted during the Reconstruction era. That means we do have a sense of what comes next. As with those past rulings, today's decision is likely to result in tangible harm to real people. At a minimum, it will deprive Medicaid recipients in South Carolina of their only meaningful way of enforcing a right that Congress has expressly granted to them. The court today disregards Congress's expressed desire to prevent that very outcome.
Now that we've walked through all three opinions, let's step back and examine where the justices joined and departed from each other, where they found common ground. Interestingly, all 9 justices agreed on the basic legal framework. Everyone accepted that for a federal statute to create rights enforceable under Section 1983, Congress must speak with clarity and use unambiguous rights-creating language. Justice Jackson's dissent didn't challenge this standard. She argued that the Medicaid provision easily met it. The justices also unanimously agreed that spending power statutes deserve special scrutiny. Even Justice Jackson acknowledged that states need fair notice before they can be sued under Section 1983. The disagreement wasn't over whether notice matters, but over what constitutes sufficient notice. The fundamental fracture. But that's where the consensus ends. The majority, led by Justice Gorsuch, essentially erected a fortress around Section 1983 enforcement. They declared that only statutes that look exactly like the nursing home provisions in the Talevski case can create enforceable rights. This FNHRA or bust approach, as Justice Jackson called it, dramatically narrows the pathway for civil rights enforcement. Justice Jackson saw this as judicial overreach in the opposite direction. She argued the majority was rewriting the test, substituting their own restrictive requirements for what Congress actually wrote. Where the majority saw necessary limitations, Jackson saw the systematic dismantling of civil rights protections. Justice Thomas goes even further. Then there's Justice Thomas, who agreed with the majority's result, but wanted to go much, much further. While the majority was content to apply existing precedent restrictively, Thomas called for a fundamental re-examination of Section 1983 jurisprudence. He argued that virtually the entire modern understanding of the statute exceeds its original scope. Thomas made 2 radical arguments that neither the majority nor dissent embraced. First, he contended that spending power statutes can never create enforceable rights because they're merely contracts, not laws that secure rights. Second, he suggested that our modern conception of rights is far broader than what the 1871 Congress intended. The historical battle. This leads us to perhaps the deepest disagreement: how to read history. Justice Thomas painted a picture of Section 1983 as a narrow, rarely used statute that only exploded in scope due to judicial activism starting in the 1960s. Justice Jackson pushed back hard on this narrative. She suggested that the low number of early Section 1983 cases reflected the dangers of filing civil rights lawsuits during the Jim Crow era, not the statute's limited scope. As she put it, filing civil rights lawsuits during the Jim Crow era could be quite perilous, especially for the people whom the statute was originally meant to benefit. The enforcement dilemma. All three opinions grappled with a practical problem. If not Section 1983, then what? The majority suggested that federal funding cutoffs and state administrative processes provide adequate enforcement. Justice Jackson was skeptical, noting that funding cutoffs rarely happen because they harm the very people the programs are meant to help. Justice Thomas was the most radical here, essentially arguing that many of these enforcement mechanisms shouldn't exist at all if they exceed the statute's original scope. This case exposes a court wrestling with fundamental questions about federal power, civil rights enforcement, and judicial interpretation. The majority reflects a conservative approach that prioritizes state sovereignty and judicial restraint. Justice Jackson represents a more expansive view of civil rights that emphasizes Congress's broad remedial purposes. And Justice Thomas embodies an originalist approach that would dramatically reshape decades of civil rights law. The real tension here isn't just about Medicaid or health care, it's about the role of federal courts in protecting individual rights against state power. That's a debate that goes straight back to Reconstruction, and as this case shows, it's far from settled. Case implications. Let's turn now to case implications. The immediate implications of Medina versus Planned Parenthood South Atlantic extend well beyond Medicaid provider disputes. The court's restrictive application of the unambiguous conferral test effectively raises the bar for all future Section 1983 enforcement claims involving spending power statutes. Federal agencies, state governments, and civil rights attorneys will need to recalibrate their understanding of what language Congress must use to create privately enforceable rights. The majority's insistence that statutes must closely resemble the Federal Nursing Home Reform Act provisions from Talevski creates a narrow template that may prove difficult for other federal programs to satisfy. This could affect enforcement mechanisms across numerous areas where Congress conditions federal funding on state compliance, from education and transportation to housing and social services. Justice Thomas's concurring opinion, while not controlling, signals potential future challenges to Section 1983's scope that could prove more consequential than today's ruling. His call for fundamental re-examination of the statute's bounds, particularly his argument that spending power legislation cannot secure rights at all, represents a far more radical restructuring of civil rights enforcement than the majority embraced. Meanwhile, Justice Jackson's dissent highlights the enforcement gap this decision creates. Federal funding termination remains theoretically available, but practically rare, potentially leaving beneficiaries of federal programs with limited recourse when states fail to comply with congressionally imposed conditions. The competing historical narratives offered by Thomas and Jackson suggest that future cases involving Section 1983's scope will likely continue to generate sharp disagreements about the statute's original meaning and proper application, making this an area of law that remains unsettled despite today's definitive-sounding ruling. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Up next, Gutierrez versus Science. Talk to you soon.